who have joined in, welcome. This is one of a number of webinars that we will continue to host for our membership and for the industry in total. And we also want to thank our 2021 annual sponsors, Mako Pool Covers, Middleton and Company Insurance, Florida, Loop Lock, Rue, and Hayward. If I can ask everybody, as the screen says, please remain on mute when you're not speaking so that we can keep this as organized a process as possible. Questions can be entered in the chat box during the presentation, and we'll open for discussion after the presentation. However, if you can put in the chat box, our panel will consider answering it right spontaneously. And upcoming events. We've got March 30th at 6 p.m. Cybersecurity, How to Protect Your Business by Middleton and Company Insurance and Rue Insurance. I know them very well. I think it's going to be a riveting webinar. On April 13th at 6 p.m., Chlorine Reduction by Blu-ray XL. And save the date, August 17th, we've got our annual golf outing, not to be missed. And I understand we're actually going to do this in person, which is going to be a great opportunity for all of us. All right, escalating equipment prices gone through the roof. Supply and demand is killing us. How do we negotiate our contracts? And our first guest speaker is Mark Warshaw. He is the CEO of Bel-Aqua Pool Supply. Mark is a current and very active member of NESPA Metro Chapter Board of Directors, providing what has been a valued service and resource to the pool industry and our association for so many years, I can't even remember. And he hosts a wonderful party at Atlantic City that not to be missed, but you have to get an invitation. I'm working on that. Mark will be giving an overview of material prices increases affecting the pool industry. Ladies and gentlemen, Mark Warshaw.
Thank you very much, Richard. You're always invited. So can everybody, obviously everybody can see me. We talked a little earlier about, I guess right now, if you want to send us a question, you could put it in the chat, or we can just wait till after and answer some questions. So we put this together, I think, quickly in the past week or so. And this is a topic that I've been discussing with my customers, and I'm sure my competitors have been discussing with their customers for really for months now, but now it's really gotten a little bit, it's really taken a turn where some of the pricing is escalated so much and our dealers are selling so far forward that I think it needs to be handled in contracts. So I'm just going to give you a little bit of history of typically the way the season works. So typically, and you guys know this, and anybody put in the chat if you want a question, but usually we get a September, October price increase. Maybe it's 3%, 4%, 5%. Dealers are probably aware of it. A lot of dealers try to do job costing, but if they don't, they just typically bump up their numbers 3 or 4 or 5%. And that's the way it goes. And last fall, we knew that last summer we would have difficulty with supply. So we knew supply would be an issue. And we got the price increase, and everybody thought, I mean, all my major manufacturers told us that, 2021 should get back to normal. Things should be okay. All of a sudden we had the chlorine issue. So you guys know that there's a chlorine shortage, and chlorine is up 30, 40%. So that was a major hit. And then all of a sudden around October, November, we started getting another round of price increases, which this is before anything. I'll talk about Texas and stuff like that. But we started getting another round of price increases where manufacturers saying that there's shortages in raw materials. And we started getting another 3, 4, 5% price increases. And then, as you guys know, if you buy steel pools, that had 2 or 3 increases. I'll share my screen in a second. and we have a tremendous amount of shortages in the industry. I'm actually going to share my screen here. So what was happening was I started getting really concerned because my dealers are selling so far forward. They're buffering their prices for, what would be a normal year, and the price increases are double digits. So if you had if you were selling a $50,000 pool and maybe your materials is $20,000 out of the 50, and you budgeted for 3 to 5%, and all of a sudden that pool is up 15%. I mean, that's a considerable amount of money that you need to make up. So I really started getting concerned, and somewhat, I'll be honest with everybody, this is somewhat self-serving. I need my dealers to run healthy businesses and make margin and do well. Obviously they need to pay their bills. I need to pay my bills. So, I mean, that's just an important part of business. But I started realizing that dealers are sold out for the year, and they sold out at like August 2020 pricing, or maybe buffered a little. So that started to become a problem. So I started to, and dealers, I know some dealers have the wherewithal to order their full year's equipment at regular pricing or at current pricing, and maybe they can take in inventory and pay for it. But most of my dealers, I noticed that they weren't ordering pools and equipment for their needs for 2021 while we're having all these double-digit price increases. So I started asking them, what did you sell the pool at, or what did you sell that job at? And they said, I bumped it up a little. So then that's when I started getting concerned about some of the price increases. So actually, I'm going to share my screen a second. You guys see my screen? All right. So
Yes, we do.
So then we started getting price increases in different sectors of the market. So steel, resin, and then I started looking to see if other materials are up, and I started Googling like price increases. And as you can see, this was something from January 4th. Because of increased demand of steel, supply shortages heading to 2021, steel has reached levels that haven't been hit before. Record high lumber prices, so housing pricing is up. U.S. manufacturers grapple with steel shortages. So we have shortages and we have price increases, which is, is a big problem. So then I started saying, you guys need to start handling this in your contracts. How can you start handling for material price increases in your contracts? Because if you sold something for $1 and now that's $1.10, and everybody started saying to me that I can't go back on their contract. My contract is set. How can I go back and ask a homeowner for more money on the contract? So that's when we put together this concept, and we started talking about what can you do in the contract to protect yourself, which Michael's going to talk about in a little bit. So that was into like November, December. I know there's a lot of people on here. January, we started seeing, again, double-digit price increases and multiple price increases that dealers didn't account for. Then all of a sudden, I'm just scrolling through a little bit here because it talks about resin and plastic shortages. But then all of a sudden we had the Texas winter storms, and you guys know about Texas. Everybody talks about Texas and the pool shortages, and I mean the pool damage, and Texas is like 18 or 20% of the nation's pool supplies, and they of in-ground pools, and they had double-digit weather for a week, and they don't winterize their pools, and the pools couldn't run because they had a lot of power outages. So they had a lot of damage. So that's affecting a lot of shortages. But what Texas also is it has, I'm going to play a little video for you in a second, but it has about 80% of the resin manufactured in the country today for everything that's needed. And a lot of pool, obviously pumps, filters, heaters, a bunch of stuff are all resin. So all of a sudden my manufacturer started declaring force majeure, which is Michael's going to talk about that, but I'm going to play a little video for you here a second so you can see, hopefully everybody can see my screen. You guys see my screen? Take a look at this a second, and you guys might recognize this company.
Major deep freeze, which many Texans are still recovering from today.
But they're not the only ones. As 2 on Your Side's Nate Benson reports, that major weather event is having an impact here for a manufacturer in Western New York.
85% of the polyethylene made in the U.S. is made in Texas. Well, why does that matter? Because polyethylene is the most widely used plastic in the world. And without Texas shipping any of it out because of the deep freeze, we might be seeing a plastic shortage, and that'll impact your store shelves soon.
When a problem like the cold weather in Texas pops up, it has an echo effect, if you will, like a pebble into a pond.
Jack Ampuja is the executive director at the Center for Supply Chain Excellence at Niagara University.
We're seeing the impact of that. Although we didn't have the problem here in Western New York, obviously we're being affected because of products coming up from Texas. So how do you prepare for something like that? But I think that companies are beginning to realize some of the inherent risk that they're dealing with.
The footage you're seeing of manufacturing inside Comfort Plastics is from a story we did in 2017. Bob Comfort is the president of Comfort Plastics in North Tonawanda, and he says they're dealing with that risk directly, and his company has never faced a raw materials shortage like this.
And we've gone to the point right now of declaring force majeure, which is basically washing our hands of contractual obligation when it comes to delivery time and prices, because this is an act of God beyond us. And we've never done that in our 48 years of business. And that's with dealing with the blizzard of 77, oil embargoes, COVID, the Great Recession. Never had to declare that before, but we've done it because of this event.
I mean, are people going to see shortages in stores of plastic goods?
Consumers are definitely going to see a shortage in consumer goods, and that could be food stuff, because the packaging is going to be missing. This could be Clorox wipes, things like that are needed for cleaning up for COVID, because you won't have containers in which to store them. Preferential treatment is always going to be that food processors, packagers, medical equipment, they get it before automotive, they get it before consumer goods. So we're going to end up being last, but you're going to see this trickle down through the economy over the course of the next 2-3 months.
The electricity is already turned on in Texas, but this is not going to be a 1 or 2 day recovery. It's going to be several weeks before things begin to smooth out.
Confer says the impact of this storm might impact his business for the rest of the year. Reporting in North Tonawanda, Nate Benson, Channel 2 News.
So let me just shut that off. Sorry.
So right here, well, I'm going to show you something right now.
Hold on. Okay, so force majeure. So I'm a customer of Comfort Plastics. I'm just gonna, give you an example, but they declared a force majeure, canceled all my open POs. When they're ready to sell me product again, it's probably going to be up at 15 or 20%. So I had sold all that product. So now I have to go back to my dealers. And I mentioned before we were talking on the phone, I mean, I feel terrible to go back to customers that I have orders from September and have to go raise their price, but I have no choice. But this is where, why this is timely, because I can go back to my dealers and raise their price. If that dealer sold a pool or something that involved that, and their contracts are fixed, they're concerned that they can't go back to the homeowner and raise the price. I've had force majeure. PVC fitting companies have done it in the past couple of weeks. Anything with, we had maintenance products that went up about 10%. We had pipe and fittings are up. Pipes up about 30%, anything to do with resin. So that also trickled down to the major manufacturers, which is why most of the major manufacturers had another 4 to 6% price increase, which is happening in the next couple weeks. But I'll just give, from a distribution standpoint, typically we can order pre-price increase and go out to the street and have maybe our customers can protect themselves. The manufacturers are limiting what we can buy. So I can't even buy more to sell you at current pricing. So your pricing on equipment from me and most of my competitors are certainly going to be up almost 10% or more from last August pricing. So I just wanted to give you guys like a little history of it's actually current events of what's going on, because we don't see it stopping. So besides shortages, and then shortages are obviously leading to, increased demand is certainly going to increase pricing, right? Because there's less supply, increased demand, prices go up. So you have shortages in raw materials, and that's leading to the pricing. So this is important. I've been talking to my customer about this for months, and I'm just going to have one little other thing that I've seen people do, and then we'll let Michael talk about how to do this legally, and he and I talked about this before. So when I've had day-to-day conversations with dealers, and I let them know, I mean, if you, I'm just going to, break it down, but if you sold 20 pools and your pools are up $2,000 or $3,000 a pool, and you didn't account for that, I mean, that's real money. That's $60,000, right? That you need to get. So a lot of contracts, I understand, and Michael will talk about, options to change your contracts to handle material price increases. But what I have talked through some dealers, and they seem very successful. If you went to any homeowner today with the possibility of you have a contract, but a lot of homeowners, we use the word reasonable, but a lot of homeowners are reasonable. If you went to a homeowner today and you said, listen, the price is up 10%, I just need $2,000, an additional $2,000 on the job, even if it's not in the contract, I think that a lot of homeowners are reasonable today. They know that they're in line for the pool. They don't want to lose them being in line for the pool. You're just asking to help with some of the material costs. I've seen that successful, very successful. And Michael can talk to this, how you can do that in a contract and maybe amend it with that price. And then the other option, you could maybe offer them an opt out, because the truth is you could maybe give them their money back, because you probably have 10 people right behind them that you could probably charge 20% more. So hopefully there's a way to do that legally. And then if the customer balks at that, just do the job. You have the contract, do the job anyway. But I'm not saying break a contract. I'm just saying that I think homeowners and consumers are reasonable. You know, when you buy a crock pot today and it's up $50 from a year ago, which I think it is, or $40, that's a point in time. It's a real point in time the consumer sees that. When they bought a pool from you last August and you're not doing it till August 2021, I mean, they got to understand you had material price increases. So any questions? I just want my dealers to run healthy businesses. And I think that this is something that's very, you know, it's different from before. I don't see anything in the chat. So if there are no questions, I'll hang around, and I was going to hand off to Michael.
Let me just quickly introduce Michael Maneri. He's an attorney and a founding partner at the Maneri Law Firm, which was formed in 1985. He limits his practice to commercial transactions, labor issues, commercial and residential real estate matters, commercial litigation, and collections. He serves.
Excuse me, am I talking to anyone? I don't know if I am or not.
Yeah.
Okay. Back to his comment. Do you think a customer is going to pay $2,000 more on a contract?
Bear with me one second. Let me just finish the introduction of Michael, and then we'll.
Yep.
Yeah, we'll allow that to go.
Yeah.
Anyway, so he serves mostly small to medium-sized clients throughout New Jersey. He's lectured many times on the Consumer Fraud Act and the home improvement regulations, as well as on compliance with wage and hourly laws. Ladies and gentlemen, Michael Maneri.
Thank you. Thank you very much, Richard. Thank you. And we will answer that question, I think, first here. Before we do anything, I do have to give you a disclaimer. While I am a lawyer, I'm not your lawyer, okay? I don't represent any of you at this moment, and any advice I give today is not necessarily legal advice that you should follow for your business. Each of your situations is unique, and if you need legal advice, you should certainly seek out an attorney of your own choosing. Having said that and gotten through that, we did have one question. Actually, I'll not necessarily throw it back to Mark, but Mark, if you could just expand upon that a little bit, and then I'll take it from there. The question was, I think, you know, are homeowners actually giving that extra $2,000? You and I spoke about that. I think you had a very good take on that. So if you could just answer.
So it's 100% been happening. It's all in the delivery. I mean, if you go to a homeowner that, let's say, you know, you could tell them the prices are up $4,000 and I'd like to split it with you $2,000. I could give you a letter showing that their price is up. But I think, you know, I think that was Holly there, but I think that homeowners are extremely reasonable today. They are well aware of price increases in other industries. They know pools are a hot topic. They've been waiting to get a pool for months. If you offer them their money back in the same conversation, very often they will say they don't want to lose their place in line. They know their friends just spent more than they did probably on a pool because the same builder is up since. So I think that, and I think that it's very reasonable to think that homeowners will work with you. I'm not saying everybody, but I've seen it be very successful for a fact. I have customers that we've been talking about this and they've done it.
Mark,
Michael can tell you how to legally handle it, but they have done it.
Thank you, Mark. Let me say this. Mark and I discussed this prior, last week and a little bit this week also. And he gave me this information. And I have to say that is the most measured, reasonable approach to the price increases. If you can approach the customer in that fashion, and if a customer, of course, is willing to work with you on that, it's wonderful. As Mark indicated, if there's a massive pushback, you have, I would say, you have to put the pool in and you eat that loss. And there's a variety of reasons for that. I mean, we'll talk about force majeure. It's a word that's been thrown around a lot. We all sort of know what it means. Impossibility of performance is really what it tends to mean. When would something be impossible to perform? You can't get the steel for the pool. Simple. You just can't put it in if you can't get it. You can't get the concrete. You can't get whatever for a variety of reasons. And those reasons would typically be the pandemic reason, weather reasons. You know, they typically talk about acts of God. The shortages and inability to actually perform fall fairly well into most force majeure clauses, and also typically fall into your common law force majeure if you don't have a clause. The issue I had when I was speaking with Mark earlier was this idea of a price increase and people calling it force majeure. It's an interesting thing. Prices go up. You know, they went up more this time. I like Mark's approach because I wouldn't want to see any of the, certainly wouldn't want to see my clients make law in this regard, whether or not a price increase supports, raising a price from a legal standpoint and or refusing to do a job from a legal standpoint. And that's one of the reasons that Mark indicated, if you get a big pushback, you might be better off doing the job. I mean, certainly you should speak with your attorney about it, but a few things you need to look for before you really make that decision. One, read your contract. You may have a force majeure clause in there that may even define price increases. Many people just have these boilerplate things, and sometimes they're good. Most of the time they're not, but sometimes they're good. And they may actually have some good language in there with respect to so-called force majeure, and it may even indicate something about price increases. Read it, or have your attorney read it, or have someone look at it. That's a critical piece of this. Certainly in New Jersey, if this did go to court, any court would look at that very, very, very strictly and see what it says and how it should be interpreted. It's not all is lost, at least not in New Jersey, if you don't have a force majeure clause in your contract, because New Jersey does recognize the common law idea of force majeure. And it makes it more difficult because you're going back into the common law, but New Jersey indicates if it's impractical to continue the job, impossible to do the job. And so you might say, well, impractical. It's a very, very high standard, what impractical means. And a very, very high standard for anyone to say that a price increase of, $3,000, but maybe you were making a profit at $10,000 and now it's only $7,000 and you're losing. I don't know that gets to the level of allowing you to get out of a contract. So I caution people to really rely on that and instead work together. And I think I see that certainly with Mark's suppliers, and hopefully with the homeowners. I was thrilled to see that the pool builders that Mark was speaking with did experience homeowners who were willing to share in the pain, let's say. And I'd like to think that will happen much more often. I was glad to see that. Once again, if you don't, if you do have a price increase, if someone says, okay, we'll pay an extra $2,000, get it in writing. People forget things. We have to do that anyway. In New Jersey, in any case, any change is supposed to have a change order. We should all know that if you're in New Jersey. Certainly put a change order in for the price increase. The other thing that's critical with the change orders is there's shortages. There's a good likelihood, I would think, if you can't get materials in the time period you typically did, that your start and end dates are probably way off. You need to contact your customers like now. One of the things in force majeure, if you do want to mention that, is notice. The courts are very, very big on notice. If you can't you find out today that you can't get things, in a month, then that'll maybe put you back 2, 3, 4 months, and somebody maybe even needs to push back into next year. Let's face it, if you were putting a pool in or schedule the pool for October, November, weather may push you into 22, I guess. That's critical to tell those people immediately. that's a likely event. And I say that because, again, if you're going to have a defense of force majeure, having given notice is a critical component to that, using that defense. So one, look at your contracts. The New Jersey's Uniform Commercial Code actually accommodates and has common law provisions that actually accommodate some of these things. So all is not lost. The law, it does protect you a little bit, but not 100% for this. The New Jersey Home Improvement Act, and of course the regulations I indicated before, be very, very certain that you get this in writing, anything that you do. Going forward, escalation clauses are critical. And I think every contract should have that in any case, unless you're going to contract today and do it tomorrow. If this is something that you're scheduling out for several months, it should have an escalation clause. Now, having said that, that's a big word, I guess you could say. And there's a lot of ways you could do an escalation clause. Richard and I spoke about this a little bit, and I think I've come down to having a bland escalation clause, meaning you put something into your contract that says, if prices increase, that you can pass on the increase to your customer. And the reason I say that, typically I hate doing something that's not really clear and defined. But if we make it clear and defined, then we're going to tell our customer what we're paying for our materials. And I don't know that everyone wants to do that. That usually opens up a can of worms that people don't want to do. So you may have to do that when there's a fight, but just kind of to that person. And that's not terrible if you want to get into that fight. And of course, we'd like to stay out of those fights, which is why we'd like to have these clauses in the contract. Because if someone says, I'm not going to pay you a penny extra, I don't care what your costs are, talk to your attorney, of course, but I'll bet it's a lot cheaper to put the pool in and lose that extra cost than to litigate it. Particularly if, this came up earlier, I think before, particularly if in New Jersey, the backlash is a consumer fraud allegation. Now you're facing paying attorney's fees of the homeowner. You're facing triple damages. If the homeowner goes out and gets another pool builder to put it in, and maybe it's $20,000, $15,000 more, they could hit you for $45,000 in just in the triple damages. And the legal fees can be more than the damages. So there's a big hammer on contractors in New Jersey, certainly. I think New York has some fairly robust consumer fraud laws as well. I don't know the particulars of them, but it's dangerous to run afoul of them. And so I would say Mark's approach is just, again, measured, reasonable, approach the homeowner, see if it'll work, see if they'll come up in price. If they won't, again, you could talk to your attorney as to how strong you want to go with that and whether or not you think your force majeure clause is strong enough. And that's why it's hard to give, I can't give any advice, definitely put the pool in, definitely don't put the pool in. You need to see what your contract says to see what kind of legal ground you're on.
Yeah. Hey, Michael, if you can just touch on the change order necessity for anything that you change out of the original contract, just so that everybody makes sure that they take that step as well.
Sure. Don't be, don't think, oh, this is a great customer. They aren't going to do anything. And, they come to you and say, could we upgrade this? And can we put a bigger heater in? Can we do whatever? And you say, sure. And you say to them, well, that'll be an extra $1,000. And they write you a check and say, oh, and you're kind of surprised because, people don't just write checks without asking you usually. And here's somebody who you told them it was $1,000 more to upgrade the heater, and they sent you the money and it's done. Well, you may find at the end of this that without that change order, you won't get paid for the change order at all. And the statute is very clear. Any change to the contract, you have to have a written change order. And while it may seem cumbersome, you just have to do it. People's memories fade, people don't realize, and there might even be people out there who know the rules and know how they can hurt you by not having things in writing. So, have that something, and it doesn't have to be that formal. I think people sometimes get afraid of it because they think it has to be some formalized thing. Not really, as long as your name is on top, their name is on it, you scribble out what it is you changed, whether it's price, time is a big one, put down why the project is delayed, and have a written change order for everything that happens. Because if you do have to go after someone, that'll be one of the issues that comes up. And judges don't look real favorable upon people don't have things in writing, plain and simple.
What is an opt-out? Like, I know we were talking before. So if you did build in a material escalation clause, however you can write that, you know, what would the dealer, obviously you said to me that going forward is the most important thing right now, like amending contracts now for future, you know. So if they did build a material escalation clause, what kind of proof, how would they prove to the homeowner? What kind of proof would they need to show that material escalation? And then you mentioned that they got to build, you should build an opt-out. Like if they're not interested in paying more money, which is a real thing, it's just, you know, dollar over dollar, a little bit more, that they would have to get their money back. So can you talk to that a little?
Sure, I'll start with the opt-out and then we'll go back to the escalation clause. I think the opt-out is something that just, it has to be in there, I think. Probably in fairness, it should be in there. You price a $50,000 pool and the prices increase so that there's $56,000 now. So it's a fairly significant increase. Someone says, I can't do that. Oh, I can't imagine that the law would force the person to do that. That's number one, because it's a significant increase. But that notwithstanding, I think it's a fair provision to allow the customer to get out if there's a certain price increase. I think I would recommend, though, that, you know, negotiate in the contract that if the price increase is 5%, you know, they have to pay it. I don't know, some number that the customer agrees to. But if it's over 5%, maybe the customer has an opportunity to opt out and you know, and not finish the job. It just seems to me to make sense from a fairness perspective. In addition, another thing I thought from a fairness perspective is this, and I would imagine some customers may actually look at this. If there's an increase provision in the contract, and we're going to tie our contract price essentially to our price of our materials, there should be a concomitant downside. In other words, if for whatever reason material prices go down, the homeowner should get the benefit of that. There's nothing wrong with that. You're not losing anything because your profit on that is fixed at that point. You're just giving back the dollars that the amount may go down. And the reason I mention that is because if a homeowner does look at this, it just makes it look fairer. And it makes it look like it's not just all one way and all, you know, only goes up. And both of those do that. Your opt-out clause does that because I think at that point, the homeowner feels that they're not stuck and that you're more fair with it. You're not going to go back to them and say there's a 20% increase if you know, if the homeowner can opt out. That's one thing. You know, they're less likely to, let me put it that way. In addition, I think it may slow the customer down a little bit from getting proof. You know, Mark mentioned proof, and Richard and I spoke about this a bit. This is a tough one. I mean, you could go pretty far with this if you want to. I just don't know if people want to do that. I guess you could say if the price increases from the materials that go into your pool from the day I sign the contract to the day I put the pool in, well, first of all, we have to name a date. What's the day we put the pool in? You know, it really can't be that date because at that point you've purchased the materials. So it's a little more difficult to navigate that, but it's one of the things you need to talk to your attorney about. So number one, what's our date and time, our line in the sand for our pricing? And is it priced that day? I mean, you signed a contract March 10th. Did we look at prices on March 10th for the pool stuff? Like, I don't know. And it's a little bit of a dangerous thing for you, particularly as prices increase. If you looked at the prices a week ago and they're higher this week, you may get hurt with having a simple price escalation clause because we don't know what date we're looking at. These can be complicated. And I think when they get complicated, the contract gets longer, it gets sloppier. Homeowners sometimes get more nervous about it. And then there's more questions involved there. If we could keep it simple, that's the better way to do it. What would be simple? I'm looking at it thinking, you know, if there's a clause in there that allows you to pass along the costs and someone asks, then you could show them the costs. If there's a big argument about it, at least you had the ability to pass it along, as opposed to most contracts that we've seen, in fact, almost all of them, that there's no ability to raise the prices. You know, you've contracted for a $50,000 pool and that's it. It's a $50,000 pool, unless there's, if someone has add-ons or extras or something like that. So, but I guess what you could do, though, you could stipulate the prices that I get from Mark and say, you know, these are the prices that I have on March 10th. I'm going to put your pool in July 15th is our start date, and we intend to purchase the goods in July 1st, and whatever the price is on July 1st, if there's an increase, you pay the increase. In my opinion, now, as a lawyer, but also as a consumer, now I know what your prices are, and I don't know how comfortable contractors are with that. I don't know that you should be doing that. That's not the element here. It just opens up a Pandora's box, I think, for customers to chip away at things that they probably shouldn't be.
Yeah.
That answer the question?
Well, from Mark's perspective, Mark, what if there were to be, so there were, heaters, pumps, parts, PVC pipe, and somewhere in the contract, a statement to the effect as billed additional costs by the supplier, something to that effect, where the only thing at that point that you have to show is the additional cost, not the original cost, the additional cost that is being passed on to the contractor for the material, and that comes from the dealer or from the manufacturer.
Yeah. So what we've seen successful, and I just want to say this again, this is not comfortable for anybody to deal with. So I get the dealers and everybody not comfortable with this situation, and it's not something we had to do before. But what worked recently for a few dealers is a lot of the manufacturers have price increase letters, so you can repurpose that letter. So they took the letters, they made a binder of the whether it's Hayward, Pentair, Aquasteel, whatever, all the different price increase letters, and they said to the homeowner, so they used a proof of a manufacturer. We just recently got a price increase from another manufacturer that put out a letter. I have dealers that sold that product. They're going to use that letter from the manufacturer with the price increase to go back and try and gain 6% from the consumer they sold to. So no, none of my dealers want to show my bills because they don't want to know what they're paying. But again, using the word reasonable and consumers knowing what's going on in the pool industry, nobody wanting to lose their place in line, a lot of people not really taking the hard-nosed approach where it's a contract and, I want you to lose money or I don't want you to make as much money. The reasonable approach to a consumer today with some of those letters of price increases seems to do the trick when you're only asking for a few $1,000s. So and then as soon as you open up the word, you're welcome to get your money back. You don't even have to say why, but they know that they have people behind you and they don't want to lose their place in line. We're in a good position as far as demand, but the biggest thing, and I guess Michael addressed it, is if they do change these contracts or change these prices, to make sure. I've had dealers, just pay me on the back end. When I'm done, you're swimming and happy. It's working. It's working. These are price increases that dealers they just can't absorb all these price increases. I mean, unless you forecasted for it last August and you sold out for 2021, you can't absorb it. But Michael, I still think, how do these dealers get the language for, is it price escalation or price increases? Like you're saying they could actually write in, we reserve the right to charge you up to 5% more. And if it's over that, you can get your money back. They could actually write that clause in there.
Yes, they could write that, and they could indicate that the price that they're giving is the price as of a certain date and the material cost as of a certain date. And then they reserve the right in the contract that if the material prices go up, it actually could be anything, but maybe you could put a buffer in there. If there's more than a 5% increase, 4% increase, whatever. I mean, it's a negotiable type of a thing, and whatever you feel comfortable with. If the material prices go up more than 5%, then you can pass on anything over the 5% to the customer. Now, the proof of that is the issue, as we discussed before. Do we get something from Mark, let's say, that says that the price of this thing went up 50 cents, or whatever, $50, 100, whatever it happens to be. So now we don't necessarily have to show that we paid 100. We based it on $100, and now it's worth, the price is $110. So we're going to ask you for $5 more. That's one of the things you need to really discuss and sit down with your attorney when you put this together, as to how detailed you'd like your price escalation clause to be.
And Michael, how much of that information actually has to be in the contract, as opposed to if and when you have one of your customers or a couple of your customers actually, put your feet to the fire and they're in dispute about the increase.
That becomes, now it's a business decision. That's a great question, Richard. That's a business decision. I mean, from people who look at contracts and say, let's make them as clear as could be. Let's say that the pump costs $2,372.80. We want to list everything, and every piece of this thing we want to list. It's impractical, first of all. So I think if you were to just simply indicate that if their costs go up, that you can pass it along. Now at least you've got the door open. You can do it without breaching the contract. See, one of the things, my concern is this: you go to a customer, and there's a little finesse here. You go to a customer, as Mark's clients are doing. They go to a customer and say, listen, I've got a $4,000 increase on these things. If you could just help me out and pay another $2,000, that would be good. If you can't do it, I'll give you your money back. That's not bad. The customer has an opportunity at that point. You haven't breached the contract yet. If you went to the customer instead and said, listen, I have a $4,000 increase. If you don't pay me $2,000 more, I'm not doing your pool. You probably breached the contract. Your defense to that is a force majeure clause, which I indicated earlier. You'll spend way more money, litigating that force majeure clause than you would probably would just putting the pool in and eating that those extra dollars. So what a price escalation clause does is it stops you or helps you to not be in a situation where you could be violated or you could be breaching your contract with the customer because you're not going to show up and do the pool. Now, of course, you have all kinds of problems because, again, in New Jersey, breaching the contract is a breach of a Consumer Fraud Act. You've breached probably a lot of other things in there. And when they sue you, they can get triple damages and attorney's fees. There's a myriad of reasons why you just can't walk away from it. Whereas if you had an escalation clause, as good or bad or detailed as it is, whatever, at least it's there. And now you're not in that situation where you're in a breach of contract situation. So I think it's really a comfort level, Richard. How detailed do you want to be in there? What do you want to say? How do you want to say it? If it all comes to a large litigation, everything's going to be on the table anyway. We just hope it doesn't get to that point.
Yeah.
What about dates on, if your contract has dates now and you just can't get the material to even do the start date or the end date, how do you make sure you cover yourself on that in contract? But you're probably okay.
You're actually okay by statute. Your contract, it's good if your contract says something like that, subject to availability of supplies. It's always nice to say that. But actually the Consumer Fraud Act, or the UCC, New Jersey UCC takes care of that. And actually even in the Consumer Fraud Act, yes, you have to put a start and an end date on this thing if you can't do it because you don't have supplies and you've tried to get the supplies. It has to be very real. It can't be that you can't get supplies because your credit is so bad with all the suppliers, no one will give it to you. It has to be something like we're experiencing now. So you can move that. What you have to do though is something I mentioned earlier, give notice. Everybody should give notice. If you know today, March 10th, that you can't put that pool in July 7th because of whatever, you have to tell those people now and then not only tell them, but sign a change order changing the date. So it's not July 10th anymore, or July 7th. We're going to start it on August 15th and it'll be finished on, September 4th, whatever.
Are you only talking about New York and New Jersey?
Well, these are New Jersey. I'm not real familiar with New
She's from Connecticut.
I'm from Connecticut. Thank you. All right. So are you only talking about New Jersey and New York?
Well, I think the force majeure is probably very similar in almost every state. So I would say the notice provision is probably universal. I'm not an attorney in those places. So I think notice is critical. The little nuances that New Jersey has are that I speak about every so often, mold into that a little bit, but certainly the notice provisions on timing is critical. When you think about it, today you can't put that July pool in, but you tell them June 30th. I can't imagine some court being sympathetic to you at that point. So to a large extent, it just makes sense to do that, plain and simple. Right. Notwithstanding that, of course, if you're going to raise a force majeure defense, the force majeure does require a pretty strict level of notice.
Right.
So certainly in New York and New Jersey.
Right. So when when is it okay to walk away from a job if it's not profitable, or walk away from a sale? Like, I'll just give you another example. A lot of spa companies are doing this. And, if you have a retail store, maybe you experience this, but there's some spa companies that sold spas. Let's say you sold a spa for 10,000. Let's say you bought a $10,000 spa, hypothetically, and you made $1,000 on the spa, which you shouldn't, but you thought that was a good deal. And now that spa, I know for a fact, a lot of them are 10% from, like, so you sold a spa last September for 10, you bought it for 10, you sold it for 11. Now the spa's costing you 11.5. So you literally lose $500. You have a contract. Is that force majeure where you declare force majeure? I mean, can you walk away from a sale giving them their money back because you're going to lose money?
I have to give you the lawyer answer, Mark. It depends. That's a tougher one. That we're getting now into the force majeure is something that's been rarely used other than these kind of times. And New Jersey
I've had
does
about 6 or 8 of them in the past 2 weeks, literally.
Exactly. And how many did you have in the past 20 years?
Never. No, I've never even. And I had to Google it like 6 months ago to see what it meant.
So there you go. And what that means is courts haven't really defined this very well. So you give a great example. Should you do it? Should you not do it? We're in business and we have danger there. If you refuse to deliver that spa and someone decides to sue you and say, I was damaged for whatever reasons, first of all, I don't know what their damages are. The damage seems to be, it would be what it costs to buy another one. So I don't know that you want to go through that hassle or just put the spa in. I'll say that again. Certainly what New Jersey courts do, and I think most courts do, is this: on a breach of contract, the court tries to put you in the position you would have been in had the other person not breached. So, had the spa dealer delivered the spa for $10,000, you would have had a spa, and you would have spent $10,000. Now the spa dealer breaches the contract. We go out to a different spa dealer, buy it for $11,000, and we sue the first one. Well, courts would say, if their first person breached, the first company pays $1,000 to the homeowner because that puts them where they would have been had the breach not happened. So you're starting to look at smaller numbers here. Is it worth getting into a lawsuit about? It gets back to a business decision. I mean, sit down and talk to your attorney about it. But certainly from a force majeure standpoint, but you asked that specifically, does it rise to the level? It might. The problem is we don't have enough case law about this. I mean, again, New Jersey talks about impracticability, but the typical situation that you see with impracticability with almost all the cases is not price, it's performance. That's where we have a problem here. It's always performance. People try to get out of performing because, it just didn't make sense to perform anymore for whatever reason. But the cases that we've seen out there don't necessarily go towards price. So it's a difficult one.
This is all price. Everything they're doing for me is price, because they're literally, they're canceling my POs that I placed last fall, null and void, even though they acknowledge them. And then they're, saying, you can buy it at a new price. We can't afford to sell you at that price. It seems like most of it, there is definitely some supply, but a lot of it's price.
Someone will litigate this. I mean, there's one of the things we've seen is, just, I don't want to get into a case law and things, but a bunch of tenants in New York have not paid their landlord. Landlords have sued, and like stores, retail stores have said, hey, we couldn't open. We had a government shutdown saying we couldn't open the store. And so we now are claiming force majeure. We can't pay your rent. And basically all the cases I've seen in New York, all the tenants lost. You had to pay your rent. So when it goes to price, I don't know how the courts are going to view that. That's why we spoke again earlier about this. It's a new area. I'm not so sure that price thing will hold up. But what I think will happen is exactly what's happening now. They let you know about it. They told you in advance. You've adjusted. You've talked to your people. We're having this meeting. We're letting people know what to do with this and trying to ameliorate the problem, as opposed to just having some massive litigation going on about a price increase.
Right. Last question. I know we're getting towards the end, but if somebody wants to do a price escalation clause and an opt-out, can they do a single sheet and attach it to their contract, or they have to do a whole new contract?
You could contracts could be many pages, so that's fine. You could do a single. Certainly in New Jersey, you could do a separate agreement, a contract. It's always better to have them sign it. The difficulty there is then it's nice to have people sign all those pieces, because what will they say? I wasn't attached to the one I signed. So just from a legal perspective, it's nice to have them sign it, initial it, or something like that. So can it be separate? Absolutely. Absolutely. Yes.
So
Yes, I think we have a question over here. Sure. You have to
Somebody have a
unmute.
question?
You need to unmute.
Yes, I'm sorry. I don't know who you were calling on. Sorry about that. Was it me?
William.
Yeah,
Yeah,
William.
go ahead, William.
Okay, I wasn't clear if it was me or not. Okay, good. Let me drop my hand. So anyway, I did take a quick look at my contract, and I do have a force majeure clause, but it doesn't include pricing. And I'm wondering if what would make good sense is a combination of two things. You know, a mild force majeure is sort of what we have, combined with Mark's very diplomatic and I think great professional approach. You know, so I have a clause that says contractor shall notify buyer of any delays caused by adverse weather conditions, acts of God or war, labor strikes, issuance of any federal, state, or local ordinances affecting the work, and all start or completion dates provided herein will be adjusted accordingly. Now, would it be acceptable, you think, to just put something in there about, and include pricing in there, just say, you know, price increases, and then the last statement would be, will be adjusted, prices and time will be adjusted accordingly. So, and then if you put something simple and not offensive in like that, you could take Mark's approach and say, hey, it really happened. You know, here it is. So I'm just wondering if that would be a logical solution without offending clients and prospects.
Real quick, I just wanted to add in, Michael and I talked about this sort of at the beginning. In New Jersey, contractor can't win. It's virtually impossible. So I think what's key, everyone seems to have some things to offer, and it's great. The more different input and advice we get, it helps everyone. But what I've found now, with everything so unpredictable, everyone I've spoken to, if you communicate and you're reasonable, just like you said, without trying to create a conflict, times are difficult. I haven't gotten any resistance. But if I said, you know, which is just not happening, and then, or you owe me this or that, tones change. But literally, I said to Michael, I don't know how there's any chance a contractor can win in the state of New Jersey. So I think just being nice and communicating up front is the easiest thing to do.
Right.
You know,
I think-
I absolutely agree with Isaac on that. And to go to the question here, though, if it's not in the contract, you can picture a homeowner saying, well, it's not here. Come on. You know, someone just giving a little bit of a push. So your question, you know, is it okay just to put it in there? Having something's better than nothing. Let's put it that way. Should it be a separate thing? I've said this story 1,000 times. I mean, first year contracts law, the first thing you learn is that everybody has a duty to read. Everybody. You sign a contract, you read it, you know exactly what it means. And for the rest of law school, basically everything we talked about was how that doesn't work and how people can get around that and the defenses to it and everything else. So if it's something important like a price increase, I'd hate to bury it, because somebody will claim they didn't see it, they didn't understand it, they didn't know it. Again, you talk to your attorney about it, you know, it should be plain language. Actually, I kind of like the idea of having something like on a separate piece of paper now, because it highlights it. That's one of the reasons why New Jersey requires certain things to be highlighted in home improvement contracts, like pool contracts, because there's certain things that the state really wants people to see. And
Right.
we have just a few minutes left. So one of the things that Isaac brought up, and Richard also mentioned that I have to talk about very briefly here, is this. One of the things that we said here was, you know, go see your attorney, have your contract looked at for escalation clauses, force majeure clauses, really look at those things while you're there. Get your contracts fixed and complying with the home improvement regulation. Isaac is absolutely right. When you don't comply with these home improvement regulations and don't have a contract, you can't win. And one of the reasons you can't win is because of the hammer that you're facing. You know, you sue the homeowner because they didn't pay you $25,000, $30,000, and then you think, yeah, that's a decent amount of money to sue on. And boy, it just isn't, particularly when the homeowner sues you back and the homeowner gets their attorney's fees if they win, and I'll talk about what win means, and triple damages, they show any damages. Some judges think a win means they just have to show that you violated the Consumer Fraud Act and the home improvement regulations. I don't want to be like disparaging, but every contractor, every time a homeowner comes in with a contractor client, there's 5 to 10 violations. Get your contracts done right. It's not that difficult. You get it done once and use it forever. Things might change. I understand that, but it'll be 1 change, 2 changes, something like that. At least you've got like 90%, and you're not facing such an onslaught of problems and issues. The times I've seen contracts come in that were pretty good, sometimes I'll talk to the contractor and I'll say, gee, you're one of the few people I've seen that has a good contract. And 100% of the time, the person says to me, oh, I'm not letting that happen again. I got slaughtered in a lawsuit 2 years ago, 3 years ago, whatever. I mean,
Right.
Every person said that when their contract was good, it was because they got hurt. And so it's just too dangerous to do that. So while you're looking at your contract for these other things, your escalation, your opt-out, and your force majeure, change it to comply with the home improvement regulations. It's easy. It's not expensive. This doesn't make it a 50-page contract. It's not that big of a deal. But when New Jersey says put it in 10-point bold type capital letters, do that. It's not that, it's right there in the statute. It's not that difficult to do. It really isn't. There's a lot of things I have to say that it is a little bit more difficult to do on an ongoing basis. I get that. But the contract is something you do once. The perfect example, I see this all the time, and I won't go on and on about it. You must know your registration number is supposed to be on everything. Like everything. Your truck, your car, your paper, everything in the world, your registration number is supposed to be on. So I look at that and figure if people have business cards, you order business cards once. And then wherever you need them, you call the printer and you say, if you do that, or you print them up yourself and you say, and you just do another 200 or 300 or 500, you don't change them. So if you put your registration number on the first time, it's going to be in there forever. You've accommodated one of the things that there's almost always a violation of. So I implore everyone here, don't let people like me, attorneys like this, have it so easy and pick these apart. And I have to say, I hear the pain in Isaac's voice. He must have seen it either personally or with others. It's tough. It really is tough. Yeah, contractors are on the short end with New Jersey consumer laws. Any other questions?
No?
As Isaac says, get the contract in order because you can't win. You just can't win. From an insurance perspective, we're constantly faced with, I'm getting sued under the Consumer Fraud Act. And I said, is there any damage other than to your work? And they'll say, no, they're suing me for my work. And, we want to turn this into insurance. And unfortunately, it's defective product, defective work, not covered at all by insurance. Well, actually, there is a way. There's a coverage, contractors, errors, and omissions, which is something you should talk about at another time. But it is a coverage that you can buy for this. Shy of that, there is no insurance protection for violations of the Consumer Fraud Act under the Home Improvement Contractors. And the reason that contractors don't hear about this frequently enough is because it never makes it to court for a trial. And the reason for that is, per se, there is no defense. So the contractor essentially has next to no defense if these violations are found and there is ascertainable damage or loss. So get it done.
Yeah, and Richard, you're absolutely right. One other thing just to throw in there, most of you or all of you have an LLC or a corporation, which is wonderful. That you do it because you want to have that, you want to shield yourself from liability, and you should all do that. It's certainly a recommendation, I'm sure your attorneys would say. But if you violate the Consumer Fraud Act, we can go after you personally. So we can pierce the corporate veil, and it's just in the statute. It's not like a maybe, we just do it. So it's no big deal. And so now your personal assets are on the line for something like this. So very, very important to get your contracts look like. I'll just put it out there to New York people or Connecticut people. I would imagine that there's similar laws there. They may not be as stringent as Jersey. I really don't know. I think
they're not as stringent, but they are.
Yeah, I'm sure
there's difficult.
Yeah, I'm sure there's something there. So by all means, look at your contracts, talk to your attorneys, and get that fixed. Okay, I think we're at our time, right? I don't want to go
Yeah,
too.
thank you, Michael. Great job. We appreciate
Thank you.
it.
Thank you very much.
Thank you, Mark. Thank you, Michael.
Thank
Very
you.
good.
Thank you, everyone, for joining. Great turnout. Hopefully, everyone got some great information.
Yeah.
See you on the next one.
Thank you.
Yeah, thank you for putting this on. Yep.
Excellent.
Wonderful stuff, gentlemen. Thank you.
Thank you.
There. Have a good